Okay. Good morning. All right. So few of us today. So first of all, based on, well, let me just say, as stragglers come in, that based on office hours yesterday, I'm not sure how many of you really understand tipping liability. So there'll be one more chance before the final, before our review session, to come talk to me. That will be next week. So make sure that you avail yourself of the opportunity, because there are some, important nuances. Make sure you understand the Yun case, for example. Make sure you understand how that fits in. So from the conversations yesterday afternoon in office hours, it was clear to me that there's, at least some of you have some potential confusion. And I just want to make sure, as more of you come in, I'm just reminding, for those of you walking in, that you have one more chance to clear up any residual confusion over fine points like tipping liability. And based on office hours yesterday, I'm not sure all of you know it as well as you think you do. So you are strongly encouraged to come and ask those questions. I was surprised that so few of you have availed yourself of the opportunity yesterday. So we'll just see what happens in a few weeks, but I'm just giving you a consumer disclosure warning. All right. Letting everyone come in here. Okay, so let's talk about a couple emails I got yesterday. And first, apologies are in order to Ben Cermak. I got the Bens confused. So Ben, please accept my apologies. Both Bens are brilliant, but this one sent me the brilliant email yesterday. So apologies for getting that mixed up. Ophir sent me a great email, and as did Andrew. And now I'm looking to see how few of... Hello, Andrew. Wow. Yeah, there's... All right. Just like stalling to let everyone kind of make their way in. All right. All right, well, here we are. So Andrew sent me... So Ophir and Andrew kind of touched on the same point in their emails. I'm just going to talk about the point they made, which is a really good one. So I'm just going to read part of Andrew's email, which is, he says that I have to agree with White's dissent in BASIC. It seems obvious to me that investors buy and sell not relying on the integrity of the market price, but relying instead on the market price being inaccurate in some way. And Ophir kind of made a similar point, pointing out that in fact plaintiffs might be relying on the presence of a misrepresentation in the price. So let's think about this point a little bit more. So the idea that Andrew's making in this comment is that if you really thought that the price, remember the price of BASIC was, depressed relative to the post-merger, the merger consideration or the value of the firm after the merger announcement. And so just reminding us all kind of what that looks like, we said that looks like, basically there's this period of time when you're selling here, then there's an announcement, and the folks who sold in this window are the aggrieved parties. And Andrew nicely articulated a critique of this, which is that if you think about why you would be aggrieved, so the story that the court wants us to believe is that you relied on the value of the firm being $20, let's say if it's 20 or whatever the number was, I don't know what this was, 50, who knows. You relied on that price when you sold, meaning you would, the fraud in the market presumption basically supposes that you would not have sold if you thought that the value of the firm was different from 20. And thus, we can in fact presume causation with respect to your sale. And Andrew points out that's actually a little weird, because if you thought the firm was fairly valued, you probably wouldn't have sold at all, or your willingness to sell would actually be kind of like indeterminate. Are you willing, are you willing to go run and exchange a $20 bill for $20? How quickly will you take 2 10s and trade them for a 20? I mean, maybe if you need change, right? Or don't need change, but you don't like having change in your wallet. But if you really thought the firm was worth 20, and that was the prevailing market price, well, there's probably no reason to sell. So, in fact, you probably thought if you sold at 20 that the firm was overvalued, right? Because why would you, I mean, if you, suppose you thought, just to see the logic, that the firm was worth like $19.99. Well, if you sold at 20, you'd make a penny. So if you thought the firm was worth 19, 15, 14, 13, you would make more money by selling. In other words, the greater the distance between your subjective valuation of the firm and the market price, the more money you make, right? So if you thought the firm was worth 21, then you wouldn't have sold at 20, right? Because you would rather have an asset that's worth 21. You might think that it's temporarily depressed, but in fact is going to make its way up to 21 or 22 or 24 or 25 and so forth. And so you would have a you would not be relying on the price to sell. In fact, there's really no scenario under which you're relying on the price to sell, because if you're pessimistic about the firm, you're selling because you see an opportunity to exploit the difference between the value of what the firm you think it is and what the price is. And if you're optimistic about the firm, then you must have been selling for some other reason, like you needed liquidity, because otherwise, rationally, you would have just held on to the share of stock. This makes sense to everyone? Okay, so there's a little bit of a puzzle. And Andrew also pointed out that in his comment on this that the discussion of value investors in Halliburton, let's sort of remind ourselves what the Halliburton court said about value investors. So open your casebooks. Teaching 1Ls in the fall, so get used to this. Open your casebooks to page, where's the discussion of value investors? To page 1130. In any event, this is the last paragraph, right? There is no reason to suppose that even Halliburton's main counterexample, the value investor, is as indifferent to the integrity of market prices as Halliburton suggests. Such an investor implicitly relies on the fact that a stock market's price will eventually reflect material information. How else could the market correction on which his profit depends occur? To be sure, the value investor does not believe the market price accurately reflects public information at the time he transacts. But to indirectly rely on a misstatement in the sense relevant for the basic presumption, he need only trade stock based on the belief that the market price will incorporate public information within a reasonable period. The value investor also presumably tries to estimate how skewed it is, but that's not so crucial. Now, if you really think about that, to me anyway, doesn't make a lot of sense. Because what the court is, I mean, what is the fraud on the market presumption? Is it that prices are accurate or not? Let's make up our mind. Prices will be accurate at some point in the future, but they're not accurate right now. The court acknowledges. Yet, how exactly does that mean that, you know, the value investor, like what is the value investor relying on again? They're relying on the $20 being accurate? I don't know. I think this is a little weird. Does anyone disagree? Does anyone disagree? Does anyone sort of, yes?
So I guess I'm a little bit less bothered by this because it strikes me as there's a difference between putting different valuations on information and incorrect information. So doesn't the fraud on the market presumption come in when you literally say something that's wrong, as if we're not going to merge if we are?
Yes.
Different value from that merger?
So Allison is saying, look, I'm not bothered by this because we're in a fraud setting, and it doesn't matter that, like, we know that the price was wrong, the $20 was wrong. We know that people bought at the wrong price. But remember, this is a presumption of causation. Right? There's a very specific story here that this is about causation. Right? All right, so the value, I think the value investor, because I don't know, I mean, the value investor is a little weird of an example. The causation, the court wants you to think about it, I think. Where did my piece of chalk go? The court wants you to think about it. You notice I've given up on technology. It's just, poor AV, this was an interesting experience this semester with technology. So what the court wants you to believe is that, you know, like the value investor is someone who's like thinks it's actually worth this amount. And so what they rely on is that the price will eventually be correct. But remember, we're trying to establish causation as to the harm from the fraud. So, okay, so let's construe Allison's critique as saying, well, it could be that what the court is saying is that, like, even if you thought it was 25, your purchase in this window, I'm not seeing the causation here. Maybe, all right, maybe we'd have to think about the other direction. And then you would have sold. So yeah, I'm having trouble seeing it. Do you see it? So you would have bought here because you think it was 25, but somehow that establishes causation for your harm here. That's the problem. Yeah, Alistair.
Yeah, wouldn't that problem be solved by thinking about it as value investors buy when they perceive that there's a bargain, and it's the mispricing that creates that perception that they then rely on?
Yes, but remember, the folks who are complaining are the folks who sold. All right? So flip the direction. So imagine, like, I think maybe you'd have to do it. Maybe you would have to do it this way. So you sell in this window. You sell here, and you're complaining that you lost the difference in 50 minus 20 in this example because you sold too early. And why did you sell? You sold because you saw the price was 20. Now, I think, I'm going to charitably construe this, I think what the court is saying is the value investors sold at 20 because they thought the real value was like 18. And so the causation is still there because even if 20 wasn't the right price, 18 is the right price. And had they known about the fraud, they wouldn't have sold. Yeah? Michael?
I don't get how liquidity kind of removes you from this area, because you could want liquidity but then choose which stock to sell, assuming that the stock is accurately priced.
So if you thought, so this is back in our conversation of whether you believe the price is accurate. So let's ignore the value investor. Just suppose you think 20 is the right price. So, let's suppose you think that you're selling and you think the firm is worth 25. So the court seems to be saying that the fraud on the market presumption seems to be implying that if you think the firm is, in fact, If you sell at 20, it's because you think 20 is the value of the firm. And Andrew's point is, well, no, it's actually got to be the case that you think the firm is worth less than 20. And I added on to that by saying, well, if you think the firm, that's right, and if you think the firm is worth 25, you wouldn't sell, you would hold on to it. Unless you needed liquidity, and this was the asset you had to sell. So yeah, you could sell some other asset, but if you sold this firm at $5 less than what you think it's worth, that must be because you just needed cash. There's no other rational explanation. If you didn't need cash, just hold on and wait till it reaches the true value, right? So what story is there? Forget the value investor for a second. What story is, let's just start with fraud on the market. What story is there that you sell because you think the price is right? That's very confusing. Now, the value investor adds another wrinkle, right? Because the value investor, supposedly, the court's saying, sold because they were relying on some other price being right. And so if they were here selling at 20, it's because they think it's going to decline to 18, and thus they're still relying on the integrity of the price, where the price in quotes here is like the 18. It's like the lower level, right? And so the misinformation also was causal to their harm, and that if they had known about the merger, they would not have sold, I guess. I mean, that's my best efforts to construe it. Yeah, Magdalena.
I'm struggling a little bit to really understand, because when I look at the premises of the presumption, or premises,
Yeah.
publicly known misrepresentation, material, efficient market. So we're not talking about the price, it's about the fact that the market will adjust to the information. And the fourth one is when to trade the stock.
Yep.
There is no, and I think that Halliburton, the court really made it very clear, when I read it, is that we're not talking about the price efficiency, but about the market's capacity to adjust to information.
Yes.
So that's two different things.
Yeah. So if if you're not in an efficient market, suppose this is the moment in time when the announcement happens. Okay, it's supposed to say announce. If you're not in an efficient market, the point of the market efficiency requirement is that the price will not jump, because you won't have the high-frequency traders we were talking about in the insider trading setting. Instead, like, nothing will happen, or the price will move only very, very, very slowly, eventually reaching the merger consideration in this example. So the market efficiency assumption has to do with this moment in time when the price jumps. But I'm asking a more predicate, basic question, right? Again, no pun intended, which is, how can we believe this idea that that anyone, at any point in time, trades because they think the price is right? Notice, even the value investor thinks the price is wrong. We just got to like leapfrog ahead into the future and kind of read back in time. Okay, but putting that wrinkle aside, nobody trades because they think the price is right. That's just illogical. Remember we talked about the no trade theorem at the beginning of the course, our beloved 9 and 11. There will be a multiple choice question, at least one, with 9 and 11. Maybe not those numbers, but Git will be there. So if you're not sure, come to office hours next week. So remember we said that if there are zero informed traders in the market, the best guess we have of our firm with our 50% chance of 9 and 50% chance of 11, you're all re-traumatized by this, but remember that we said that the expected value is 10, and since that's the best guess of the value of the firm, that's the price for the uninformed buyer, that's the price for the uninformed seller, that's also the price at which the market maker will trade with you. And because everyone is agreeing that the best estimate of the value of the firm is 10, nobody will ever trade with each other, right? So this is sort of happening here. If you think about what BASIC is saying, it doesn't really make sense. At the end of the day, if you were going to trade, it's because you think that the price is wrong, or because you need liquidity. But in that event, you're not trading in reliance on anything. You're trading because you think, because you need cash. Michael.
I guess that's what I was questioning, because if you need liquidity and you
Yeah.
have two stocks,
Yeah.
I'm going to sell the stock that I think is fairly valued as opposed to the stock that's not fairly valued. So if I sold this thinking it was 20 because I needed cash, and now suddenly, because of something they misstated, it's now 50, I would have sold the other stock as opposed to this stock.
Okay. So Michael has in mind a hypothetical choice between selling this stock and selling another stock that's even more underpriced. And Michael says, look, if I'm going to make a relative decision, but I could just as easily characterize that as the causation is because the other stock is mispriced. Right? The reason why I'd be willing to sell this stock at 20 is only not because I think 20 is somehow correct. It's because 20 is more correct than the other stock that's mispriced in your example. And so as between the two, I'll choose the one that yields the least pain, because I think if I were to sell it the other case, I would definitely be making a loss. So this is 0 loss. That one is positive, so I'll choose 0. Sure, but that's not because I think the market, I mean, okay, we can pull because, stretch it, fair. But that's a real stretch. It requires a very specific set of assumptions, and it's really because of the comparison with the others. Hang on, let me get Paul, yeah?
Yes, I just want to make sure I understand with the reliance. It's not that you relied on, it's not that you traded because of the price that was in the market. It's that the market price included the fraud, and as a result, you relied on the fraud was implicit in the market price. So I feel like we're talking about like what caused the person to trade, but
hang on, slow down. All right. Let's go back to basic. Back to basics. So I'm going to read from page 1124 of the casebook. At the bottom of the court's conclusion that the fraud, well, this is Justice White restating it. All right, let's go back and go on with the do you even have this? Okay, 1122. 1121. The fraud in the market theory is based on the hypothesis that in an open and developed securities market, the price of a company's stock is determined by the available material information. This isn't giving me a good. 1122, modern securities markets. They chopped out. Here we go. 1123. The courts below accepted a presumption created by the fraud in the market theory and subject to rebuttal that persons who had traded basic shares had done so in reliance on the integrity of the price set by the market. But because of petitioner's material misrepresentations, that price had been fraudulently depressed. So you rely, just make sure this is clear to everyone, during the period when you're selling, you're relying on the integrity of 20. Okay, now you're saying 20 is not 50. Yes, that's why you're suing for securities fraud, because there was an omission that artificially depressed the price. But the reliance, what's in the investor's head that the court is construing is the reliance on the integrity of 20. So the court's saying, as the seller, you believe that the firm is worth 20. Wrongly. You believe wrongly, ex post. It turns out that you were misled. But at the moment, that's what you thought. You thought it was worth 20. And you thought it was worth 20. And in fact, not only did you think it was worth 20, you sold because you thought it was worth 20. That's the presumption of transaction causation. And it is that presumption that makes no sense because nobody sells because they think the firm is worth the current price. OK, a lot of hands. Hang on. Let me get, yes. Adi, yeah.
So maybe the reason why you would sell is because if we accept that there are other markets that aren't efficient, then maybe
yes.
you would sell when you're indifferent at the price in the current market to take advantage of other markets that are less efficient.
Yeah, so that's Michael's point. So we could construe a kind of, this is not in BASIC, and it's not in any of the case law, but we could construe like a choice of worse alternatives and say this is the least, you need liquidity, so you pick the one that's the best valued. But that's a stretch. Elliot.
Maybe it's the court showing a preference for diversification over value investors. So people who are diversified are in all these funds, and these funds are like buying and selling, not really based on value, but what the market price is reflecting in value. Versus
Yes.
value investors are typically more sophisticated and trying to arbitrage the market in some way. So maybe it's the court trying to like protect the little guy that's in all these funds and kind of showing a preference for
Yeah.
diversification among investors.
It could very well be. That's a nice point. It could very well be. The court may not want to burden you. So the court may want class actions to go forward on the idea that we want to correct misprice. I know this is not exactly what you're saying, but I'm going to kind of reinterpret it as protecting certain investors is kind of like saying insuring them against mispricing losses. And the problem is that, yes, the fraud in the market assumption does that effectively very well. But that's what we said in the insider trading context courts are supposedly not thrilled about doing. And we'll see that the loss causation steps into kind of cabinet. Sam doesn't agree. What do you think, Sam?
Oh, well, it's not in direct response,
Oh.
so I could wait if there's...
Yeah. No, it's okay.
Okay, yeah, no, so I guess I was just reading the logic of the opinion differently.
All
So
right.
there's this other passage where it says, recent empirical studies have tended to confirm Congress's premise that the market price of shares traded on well-developed markets
Yes.
reflects all publicly available information and hence any material misrepresentations.
Yes.
So my understanding was that the reliance on the integrity of the price that they
Yeah.
discuss. And so it's not necessarily the accuracy, but the fact that the price does not contain investors' reactions to misrepresentations, which it
price
does
does
if a
not-
misrepresentation has artificially depressed the price.
Okay, so Sam wants to say I'm being too broad in my construction of what exactly the fraud on the market theory is relying on. Sam wants to say it's not a reliance on a perfect alignment between the price and what I think the firm is worth. It's just a more narrow reliance. Maybe this is Paul saying too. It's just a more narrow reliance on the fact that your fraud has been baked into the price. Okay, this is a great opportunity to discuss what I wanted to talk about, just for review and refresh, because I feel like we didn't discuss this enough. What actually is transaction causation? Okay, so I feel like this conversation is somewhat murky because we went a little bit too fast through like the formal analysis of transaction causation. I just want to make sure everyone sees this very, very clearly. What was the holding in List v. Fashion Park? One sentence. Okay, if you had known, is that Kate in the back? No. Oh. You guys, it's hard enough, 130. Okay, switching seats on me. Go ahead, yes.
Yeah, I would say the individual plaintiff must back out, or it's back and reasonable.
Yes.
It must also, would also act.
But even simpler. Good. But even simpler. Okay. If you would have bought the security anyway, no reliance. It's really simple. That was the holding in List v. Fashion Park. If you were going to buy anyway, even if you had known, and Kate's right, that's what the language the court used, but just very simply, if you had known the information, right? If you had been told the facts that were not told to you, or if you had been told the truth, you would have bought anyway. That is transaction causation. Let's make sure this is incredibly clear. And the court held in List v. Fashion Park that they would have bought anyway. Therefore, there was no transaction causation. Andrew.
Just to be clear, are we conflating transaction causation and reliance?
Those are the same thing.
The same thing?
Literally. Okay. Literally. Reliance, transaction causation, the same element. All right? Just make sure this is very clear. In the insider trading setting, it is literally, go back to our discussion of how the price moves in insider trading. All this time you're trading against an insider. Insider, 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 outsider, outsider, outsider. You have to establish affirmatively that each of these outsiders who traded against an insider would not have traded if they had been given the information. That is List v. Fashion Park. That is a required element of a 10b-5 claim. You must establish that in the absence of the misrepresentation, you would not have bought or sold. In this case, you would not have sold. You would not have purchased if the price is going down. You would not have bought from Martoma as Martoma is selling. And in this case, you would not have sold. The problem is, let's just make sure this is crystal clear, transaction causation could be established in the case of insider trading because at least in the sort of traditional stories, you could always say, well, I kind of asked the counterparty, like this was affiliated, I had a conversation, and they didn't tell me about the information they knew. And had I known, or you could provide some kind of affirmative evidence, had I known that there was this bad news about this company about to come out, I would not have bought the stock at that moment. And there's at least a possibility that you can establish that transaction causation. Okay. In the case where the entire market is deceived, which is the class action setting, just remember, historically, the way that I've taught you to think of insider trading as moving prices. That's true. That's not how courts thought about it, right? Courts thought about insider trading as just kind of exploiting a market price that's not really changing until the moment of the announcement. That's how the courts thought, and how, if you think about kind of the logic, even though we said economically that's not right, the idea that insiders are kind of hiding stealthily their trades, not really moving the price very much like we saw in the Martoma case, basically means that the market is, as a whole, in the view of the courts in the insider trading setting, is not really misled. Does everyone see this? The insider trading 10b-5 settings are settings in which the fraud is supposedly happening between the insider and their counterparty. Because the insider is exploiting their inside information to defraud the counterparty. This is the legal way of thinking about it, right? This is how the case law evolved. So if I am Martoma selling to you at 35, you're buying from me at 35, I'm defrauding you because I know that the stock is worth 11. But you're not being defrauded because the price of the stock is changing in this story. You saw in Martoma, it didn't really change very much. This is how courts think about it, okay? I'm trying to help you see this distinction. So doctrinally, when we get to fraud on the market, right, what's happening here in the eyes of the courts is very different. What's happening here is that the company is denying information, thereby actually sort of inserting the fraud into the market price itself. There is no counterparty. And it's for that reason, legally, that transaction causation is a lot harder to establish, right? Because there is no hypothetical conversation, with an insider. This goes back to like common law, we said tort, think about even contractual misrepresentations. Here, you're buying on an open market just at the wrong price. So transaction causation would be almost impossible to establish because you'd have to show that if hypothetically the price were different, you would not have sold in the basic case. But in the eyes of the courts, that's a nearly impossible task. It requires proof of a hypothetical that didn't happen. Whereas here you can say, actually, Martoma was selling. And there's a little bit of a fiction, as we discussed before. This doesn't make a lot of sense economically, but we discussed before that there's this fiction that if I'm buying from Martoma when Martoma is selling, Martoma is defrauding me. And that story is a story that works here. It doesn't work over here. Your counterparty doesn't have any information. The price is the wrong price, and that's all that's happening. Does everyone understand? Are there questions on this? I want to make sure this is clear. Magdalena.
Well, yeah, I'm still struggling with this price because isn't the market looking at the price movement rather than the price itself? In a sense that when there is information, the price starts either going up or down depending on the information.
Yeah.
So when Halliburton, and I think Halliburton, there's very important sentence, and maybe if you allow,
Yeah.
read it out.
Sure.
Which says, I don't remember the page, presumption of reliance, the court explains, is not conclusively to adopt this particular theory of how correctly and completely the publicly available information is reflected in market price. The court instead based the presumption on the fair and modest premise that market professionals generally consider most publicly announced material statements
Sure.
of companies, thereby affecting stock market prices. Again, so it's not about the
Right.
specific price, but the fact that the price will start moving up or down because of the information.
Right. So Magdalena is correct to say that, just so everyone understands, the debate in Halliburton, for all of our conversations about theory, I want to make sure that you do get the basics should be very clear to you, okay? So the debate in Halliburton was whether or not prices actually jump up this fast. That was the whole issue in Halliburton. It was an academic fight over it. There was, a lot of consternation over the assumption that when the merger was announced, the price would move immediately. The resistance to that came from critiques of the efficient market hypothesis. The empirical literature that Sam quoted earlier has been largely refuted. So that was the main issue in Halliburton. But I'm not there yet. I'm still at an earlier phase, and I want to just make sure this is extremely clear. Though some of you totally got it, and some of you I'm not sure. So in a fraud on the market case, the transaction causation is almost impossible to prove because there is no counterparty defrauding you. Make sure this is crystal clear. There's no counterparty defrauding you. You are just transacting at the wrong price. So in order to establish causation, which was always an element of common law fraud, that your damages were caused by the misrepresentation or omission, we need to be able to say that the investor would have acted differently if the merger had been announced truthfully, that is, if the price were higher. The investor would not have sold. That is about the investor's behavior. And this is why I'm pushing back against, Sam, your correct, I think, recharacterization, so to speak. I think what you're saying is how a lot of people think of what the court was doing in BASIC. But what the court is doing in BASIC does not fit very nicely with transaction causation in the cases leading up to BASIC, or the way we've had transaction causation like in List v. Fashion Park in the 10b-5 setting, and what still has to be established in a 10b-5 claim. There is, and there's a nice paper for those of you who are somewhat still mystified by this. There is a paper, Business Lawyer, by Merritt Fox, Demystifying Causation in Fraud on the Market Actions. You should read it if you're still mystified. But Merritt makes this point in painstaking detail that transaction causation in fraud on the market claims is somewhat bizarre. It's somewhat bizarre. And he points out, summarizing BASIC, that unlike traditional reliance, the plaintiff no longer needs to show that she would have acted differently, not purchased the security, if the defendant had not made the misstatement. In the following section of his articles, the transaction causation framework fits fraud on the market actions poorly. Okay, so the reason why it fits fraud on the market actions poorly is because Sam's characterization of what investors are believing, they're relying on the integrity of the market price that is an efficient market, is impounded all information, says nothing about whether they would or wouldn't have traded in the absence of the fraud. And it is that question of your behavior, whether you would have engaged in this behavior or not, that is the entire element of reliance. Transaction causation. Christian.
Okay, this is probably going to be a really silly question, but since the fraud on the market doctrine is so single-handedly focused on sort of investor expectations, what would happen if every time someone transacted in a security they had to click some, big notice box or sign something that said, I acknowledge that there might be some secret information that makes the price of the security inaccurate? Would that completely defeat that?
Christian says, what if you have to declare that you recognize that? Yeah. I don't know. I'd have to think about that, right? So Generally speaking, you can't contract out of 10b5, except, there's one exception, which is very relevant to our conversation. You can acknowledge or contract out of the reliance element. So actually, you can say, happens all the time in practice. Anyone heard of big boy letters when you were at a firm? So if you're engaged in negotiations, you can say, we're gonna write a letter to the effect and agree that any representations I make, you are not relying on them in the purchase or sale of a security. It's probably the only way that you can actually contract out of 10b5. The reliance element is the only element where something like that would work. And that's because, why, formally? Why is it formally that you could contract out of BASIC? Out of the fraud on the market doctrine? It's a rebuttable presumption, right? So it's just a presumption. It can be rebutted. Okay, now two ways it can be rebutted, right? So one way it could be rebutted is if there was affirmative evidence that you did not rely on the market price, Christian's hypothetical. The other way, Magdalena's point, is that the presumption can be rebutted if the market is not efficient and not impounding this information. So that's where it fits, right? Does everyone see that? Okay. All right. Yes, so great. So now let's go to Semerenko. I was going to do that a little later, but we can do that now. So what happened in Semerenko? This is a good application of these doctrines. Davia.
I'm sorry, I didn't hear how you read, I'm sorry.
Magdalena?
Magdalena's point for the last statement.
So Magdalena pointed out that what the court is really focusing on in Halliburton, or not the only component of Halliburton, but a big issue at Halliburton, was whether the fraud on the market doctrine can work, is sustainable, will continue to be embraced by the Supreme Court if we can show that markets in general are not efficient. And there was a lot of academic writing on the fact that markets aren't efficient. And so one way you can rebut, the court at Halliburton said, look, we're not going to abandon fraud on the market because most of the time, most securities are efficient, incorporating public information. So this reaction, this price reaction, is okay, right? Like it's going to happen most of the time. It's not exactly, doesn't exactly speak to the reliance point, right? So that's the problem, right? That no matter how efficient the market is, somehow we've got to get from market efficiency to counterfactual behavior, right? The counterfactual behavior is what I would have done if I had known about the fraud. That is List v. Fashion Park. That is the common law element of causation, reliance. But for causation, but think back to torts, but for the defendant's misconduct, but for the defendant's tort, I would not have suffered the damage. But for is a statement about behavior, not a statement about prices. Sam, you don't look convinced.
Well, yeah, I mean, to me it makes perfect sense that if you knew that the $20 stock was worth $50, if that fraud, was revealed to you somehow, that you wouldn't have sold at 20.
So Sam doesn't find it troubling to suppose that if the fraud had been revealed that and the price were higher, that you wouldn't have sold at 20. Does everyone agree with Sam? Does anyone disagree? Does everyone agree? Christian, what do you think?
Well, I mean, I think that would certainly be the case for some people, but other people are selling for reasons wholly unrelated to the information on the market.
Right. Other people were selling for other reasons. Other people were selling for other reasons. So where do we draw the line? Let me push, Sam, you to think about this. Should we assume that every person who sold from the first moment of fraud, which could have been 3 months before the merger announcement, let's say, for 3 months, every actor, every seller would not have sold if they had known that a merger was pending? Every seller?
Yeah, I mean, I think in reality that's not the case, that some probably still would have sold.
How many?
I mean, yeah, there's no good way to really draw this line, but I think it's, as a result of that, it's reasonable to have this presumption. That would just be my thought.
Yeah, but I mean, 10% of them get the benefit, 20% of, 100%, because the presumption says 100%. Let me ask you another question, Sam. Do you think the $20 incorporated any chance of the 50?
Yeah, it most likely did.
Right. So the folks who sell at a price that reflects some probability of getting the compensation. So everyone under fraud on the market, everyone who sells in that period gets compensated not only for the lack of, not only as if they would not have sold, but they already have taken cash at a price that reflects some non-zero probability most of the time that the company was going to get sold at the higher valuation. So they already are getting partially compensated. At what point, Sam, right, do we draw the line and say, no, buyer beware, seller beware. If you sell, you get 5% of the price premium, right, for the chance that the firm might sell at a higher up. At what point do we say that's enough for the seller and that we shouldn't turn the firm into an ex post insurer for all sellers who sold at prices lower than what they could have had if they had held on? Where do we draw that line?
Well, I mean, I think what it really depends on is how easy it is for the firm to not put out misleading statements. Like, if we see that as a relatively easy requirement to comply with, then I don't think we should be too troubled by this. If we see that as more difficult and those lines are difficult to draw, then maybe this is problematic for those reasons.
That's fair. That's fair. I'm picking on Sam because he's one of our best corporate law students, and so this is good. But I think you should think that a rule that relies on, no pun intended again, on the assumption that, well, it's always easy to prevent fraud. Remember, a lot of these cases are brought because the duty of non-disclosure is not, the scope of what ex post is going to be viewed as material is really not clear often ex ante. So, is your drug trial, your phase 1 trial result material? Is that something that if you're asked about your clinical trial results, you should say, yeah, I mean, what do you say? What do you say if you're Elon or Wyeth, right? Dr. Gilman goes out, it's first time he saw the evidence, it was, maybe it wasn't so bad. So a lot of the times, these cases are really all about ex post insurance. It's like you thought, the news wasn't so bad, so you kind of said that. And then it turns out that the news was really bad. And now you're on the hook. So easy to prevent the fraud, right, is not, Okay, so I want you to kind of see that fraud on the market here. We can't really, our little exchange here should show you that it's very hard to draw the line when fraud on the market actually makes sense as kind of a replacement for transaction causation, because like how many people out of the 100, what percent of the sellers would not have sold if they had the information? Okay, so I hope transaction causation is very clear. If not, let's just go quickly through Semerenko, and you'll see an application of it. And hopefully after that. All right, what happened in Semerenko? Did anyone read the case? Yeah, Alistair.
Yeah, so there was a tender offer being made, or maybe not a tender offer, but AIG was attempting to buy ABI, and Cendant came in with a competing price, and there was a bidding war, and Cendant eventually raised its bid to $67 a share, which affected the stock price of ABI a lot, increasing it significantly.
Yep.
And then news started to trickle out about accounting irregularities with Cendant. And initially, they said oh, this is no big deal, it's just in a small sector of our business, we're going to downgrade earnings but like a little bit, and then they made several public statements like reiterating that like they were going to go through with the merger, and they were outraged at the effect that this was having on merger speculation in the stock price. And then it came out that the accounting error was like much larger than anybody had anticipated, and that the accounting error accounted for like a loss of $500 million.
Yeah.
And so that tanked the stock price of ABI, and the investors in ABI were suing.
Okay, so when did that big announcement happen? Do you remember the date?
I believe it was August.
April.
The first big announcement about the accounting irregularities was April 15th.
Yeah, April 15th. So April 15th is the big moment when they announce, they had engaged Willkie Farr and Arthur Andersen, Deloitte. Okay, and so what does the court basically do? That was perfect, Alistair. The court chops up the periods, right? And kind of says, okay, so we have reliance in certain periods and non-reliance in others. What periods do we have reliance? Alistair.
Well, there's reliance after the April 5th or after the April 15th disclosure.
There is reliance or isn't reliance after April 15th?
I believe that they found that there was reliance after that date, because the statement that was, or the April 27th date, because the statement that they made was like very optimistic and didn't include sufficient disclaimers.
So page 1144 tells us towards the bottom of the page, neither the market, you're exactly right, neither the that's not correct. Just let's make sure this is clear. Neither the market nor the class members could have reasonably relied on Cendant's prior financial statements or its audit reports after April 15th. So no reliance after April 15th. Why? Because there was a curative statement issued on April 15th. So there's a period of time before this announcement, right, from March 3rd to April 15th. So on 1143, we're also persuaded that the class members who purchased shares of ABI common stock between March 3rd and April 15th alleged sufficient facts to satisfy the elements of reliance. This is on page 1143. With respect to those purchasers, now so that's the holding. That's the court's conclusion as to that pre-April 15th period. Now it's going to state the defendant's claim and reject it. Okay, so what do the defendants say? With respect to those purchasers, the defendants maintain that AIG's 58 tender offer provided independent valuation. So there was this other tender offer, right, from AIG at $58. In effect, the defendants suggest, this is the court restating what it's about to reject, that the market did not incorporate the alleged misrepresentations into the price of ABI common stock during the competing tender offer, and that the class members would have purchased shares of ABI common stock to tender even if they had known the truth about Cendant. All right, so let's make sure this is ultra crystal clear. This is transaction causation. You would have purchased the shares, that's the claim, even if you had known the truth. So remember, this is the behavioral doctrine. It's like the doctrine about behavior. Okay? It's nothing to do with whether prices are right or not. That is to say that the fraud on the market presumption can be rebutted if you could show affirmatively that the plaintiff would have, the next sentence. See Basic Inc. noting that the presumption of indirect actual reliance may be rebutted by showing that the plaintiff would have completed the transaction regardless of the alleged misrepresentations. Okay. So the court rejects that. The court says, no, that's not the case. That's not the case. Why is that? Alistair, do you see why?
Because the the existence of a competing offer and the prospect of a bidding war can still drive up the price.
Yep.
And that's what the court says is the fact that there were two offers is part of why the price rose so much.
So we agree, the court says that the existence of a competing tender offer did not affect the class's reliance on the defendant's alleged misrepresentations. They're assuming that the allegations in the complaint are true. And pursuant to those, this is on the procedural posture of this case is a motion to dismiss. And so we're going to assume that those allegations are true. And as Alistair said, they're not. The court says we're going to assume for present purposes. We may not assume for present purposes that it did not also incorporate information concerning a potential acquisition by Cendant. In other words, that even though there was this AIG offer, that Cendant's offer was making its way into the price. So see how this works, okay? So Cendant has this outstanding tender offer. The probability of that, well, not just outstanding, it had been agreed upon. The probability of that merger turned on the financial condition of Cendant. So because Cendant misrepresented its financial condition, the likelihood of the merger going through is going down. And the court says, look, to rebut the presumption, the fraud on the market presumption, you need to show that the plaintiffs were, in fact, relying on the ABI offer. That is, the news about Cendant actually had no effect on their trading. And the court says, we won't accept that rebuttal. Why? So we're trying to rebut a behavioral. We're trying to establish a behavioral point. Make sure everyone sees this. The behavioral point is that you would not have acted in this way, right? That the class members, page 1143, would have purchased shares of ABI common stock to tender even if they had known the truth. So we're trying to establish a claim about your behavior. You would, nonetheless, have purchased shares of ABI to tender even if you had known the truth. But how does the court rebut that behavior? How does the court conclude that that behavioral claim is wrong? Let me just make sure everyone's on the same page. So there's in order to rebut the basic fraud on the market presumption, you have to show, you have to establish a behavioral claim. The behavioral claim is that what? In this case, that the class members would have purchased shares of ABI common stock to tender to AIG, even if they had known the truth about Cendant. They weren't harmed, the argument goes, because they would have nonetheless purchased the shares even if they had known the truth, because the presence of the AIG offer was all that mattered to them. That's the defendant's claim. That's a behavioral claim that should be sufficient to rebut the basic presumption, the fraud on the market presumption. And what does the court point to as evidence for why it's going to reject that behavioral claim? What does the court point to?
Saying that because there were two actors bidding in good financial situation, that made the investors more confident about the situation and interested to make the transaction.
Right. That's right. I'm trying to get you to see there's something simpler. That's correct.
And bid it with a better price.
Yeah, price is the word I'm looking for. The court points to the fact that the price of ABI is responding to Cendant's financial condition. Right? Look at the top of 1144. We may not assume for present purposes that the market price of ABI common stock, did not also incorporate information concerning a potential acquisition by Cendant. or that Cendent's tender offer did not have an actual effect on the class. Indeed, it is likely that the shares of ABI common stock traded at a premium. In other words, the court is rejecting a behavioral claim by pointing to the price reaction of ABI's stock. Everyone see how this is working? Yeah? So this is a little tricky to wrap your head around, but just kind of take it one step at a time. So you've got fraud on the market. Let's just recap. You've got a fraud on the market presumption, which says no need to establish reliance, no need to establish transaction causation in securities fraud class actions like these. There are certain conditions for fraud on the market, which we reviewed yesterday. All right, when those conditions are present, Magdalena gave it to us again, efficient market, et cetera, et cetera. All right. Now, we're going to try to, the defendants here, okay, the company being sued, is going to try to rebut that presumption. How do you rebut the fraud on the market presumption? You have to establish a behavioral claim. The behavioral claim, in this case, is that the class members would have nonetheless purchased the shares of ABI common stock. So remember, they're buying them at a price that's too high. The behavioral point you have to establish is that they would have engaged in that behavior. They would have gone out and bought those shares anyway. That destroys transaction causation. Okay, I hope this is clear. The court rejects that claim. Okay, the court says, no, 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 you have not rebutted fraud on the market. No, no, no. You have not rebutted fraud on the market. Why? Well, the market price of ABI is moving in response to news about Cendent. Actually, the market price has incorporated information considering a potential acquisition by Cendent, and the shares of ABI are trading at a premium. In other words, this links it back to Magdalena's point about efficient markets. We're going to kind of use market efficiency as evidence of behavior, right? That is, we're going to use the fact that the price is responding to Cendent's offer here as evidence for the for the fact that it cannot be the case that they were not interested in that market price, right? So the idea that that what was happening here was that members of the class didn't care about Cendent's financial condition or Cendent's offer cannot possibly be the case. It cannot possibly be that they didn't care because the price was changing, and because the price was changing, that's evidence that investors cared. And that's how the court in Semerenko is linking the fraud on the market, which is really all about how fast and rapidly the markets update and incorporate information into prices, sort of linking that to a behavioral claim about what investors would or would not have done. All right. Does everyone, any questions on this? Alistair.
Looking at 1146, it seems like the court does also finds that they could have relied after April 15th in between that and July.
Yeah, you're right. Yes.
And I'm just wondering, is that theory at all different, or is it just the same logic applied to a slightly different set of facts?
So you're right that after so there's this July 14th announcement that it had. So just to be clear, while the court concludes that so we just had this entire conversation about the disclosures prior to April 15th. Then there's a discussion of the situation after April 15th. So if you want to see when there is no reliance, you just read the paragraph on 1144, sort of taking this one step at a time. We agree, this is the middle of the page on 1144, we agree that the class has failed to demonstrate that it was reasonable for its members to rely on the defendant's prior financial statements and auditor reports following the April 15th, 1998 disclosure. In other words, no reliance after you're told what? You're told, you're warned. Okay, Cendent disclosed on April 15th that it discovered accounting irregularities. It warned investors not to rely on its prior financial statements and auditor reports. The complaint further alleges that the common stock traded in an efficient market, the market price instantly dropped after Cendant issued a warning. Therefore, from that point on, if you bought after you read that announcement, you could not claim that you relied on the misrepresentations made before that April 15th curative announcement. And what is the evidence for that? What is the evidence for lack of reliance? You should now have this. It's the market price, again. So the market price dropped. Therefore, it would be unreasonable for you to have, and again, we're making an inference about behavior. We're sort of looking at evidence of, but we can't actually say hypothetically what these investors would or would not have done. That's the problem with proving transaction causation and fraud of the market settings. But we can say that if the price fell, then that kind of reflects this general recognition that anything that was true, was said beforehand, could not possibly have been true. Therefore, there's no reliance if you bought after April 15th, too bad. So you see how what's happening in fraud on the market is the courts are using the change in the market price as evidence of investors' hypothetical behavior, trying to establish a hypothetical, what you would have done if you would have known the truth. But because that's impossible to prove, because that's like reaching into a counterfactual world that doesn't exist, we're going to look at how the market price changes as evidence of investor reactions to the information. And that is a leap, and it blurs the lines, but that's the law. You want to understand how that is operating here. Now, to Alistair's question, the court says, the bottom of 1144, we do not accept the defendant's contention that the class could not have reasonably relied on the alleged misrepresentations that were included in the April 15th, 1998 announcement. In other words, the court, then there's a third period that the court is looking at. This is a tough opinion, so you might want to reread it after class. The third period is the actual content of the April 15th announcement. And here the court says, there is reliance on the content of that announcement. And there's a discussion here of the bespoke caution doctrine because the announcement contained this qualifier that representations were subject to known and unknown risks. And a lot of the discussion here is around whether the bespoke caution doctrine, in fact, applies. We don't need to get into that for now. But the bottom line, the court says it doesn't. And so, Alistair, to your point as to July, what the court says here at the end of 1146 is that the class was not entitled to rely indefinitely upon the misrepresentations in the April 15th announcement, that at least as of July 14th, it had announced yet another restatement that could have cured the misrepresentations in the April 15th announcement itself. But just so everyone sees this, the misrepresentations in the April 15th announcement are not that important. Like, they were important in this case. But I want you to see you've got pre-April 15th and post-April 15th. And before April 15th, there is reliance. After April 15th, there's no reliance. Effectively, fraud, you might say fraud on the market is rebutted, maybe, after April 15th. Not exactly, though, right? Because they're using the market price to rebut reliance. That isn't really a rejection of fraud on the market. In fact, an empirical study, I think it was out of Stanford, found that fraud on the market was actually rebutted successfully like 6 times in the past 20, 30 years. So in Semerenko, you can see that there's, we can use the fact that the market seems to have accepted, a restatement of accounting figures as destroying reliance, but that's really not technically a rejection of fraud on the market. To reject fraud on the market, we either need to show, as Magdalena pointed out earlier, that the market is not efficient. Good luck trying to prove that. Very hard. Or, what some have succeeded in doing very occasionally, that there's actually subjective evidence as to this behavioral point. What would that kind of evidence look like? Well, imagine that you were sort of wiretapping, right, the investor who says, yeah, I know that price is wrong. I know that they're probably hiding something, but I'm going to go ahead and sell anyway. I don't care. Or as Christian suggested earlier, you could rebut the presumption theoretically at least, by having some kind of waiver of reliance, right? That I make, go into this transaction, accepting the possibility that I'm being defrauded. And big boy letters are kind of like that. That's kind of what they do. It's where we're going to have a conversation. We all understand that this conversation will contain omissions and potentially misstatements even. But we agree that for other reasons, we're perfectly fine having a conversation that has misstatements and omissions. And we agree that we're not going to rely. That should rebut fraud on the market, right? That should be the kind of evidence. I don't know if it's ever been tested. I don't think Merritt Fox and I were talking about this. I don't think it's ever, big boy letters as rebutting reliance have ever been tested. But maybe they will be in a few weeks. OK, other questions? Does everyone see this? That was convoluted and complex and no questions. So you're worrying me a little bit. Maybe you all are brilliant and you all got it. I mean, definitely all brilliant, but nobody has any? No one will ask a question. OK. All right. OK. All right. Rule 20, come to office hours. If anything I just said was not clear, come to office hours. And for those listening via video, come to office hours. All right, just come anyway. OK, Rule 23. Rule 23. So I'm going to talk for the next few minutes about some of the procedural points. Take a look at the paper I sent out via email, Alan Farrell's paper on price impact versus materiality. Notice that Halliburton 2 allows for the absence of price impact to rebut the basic presumption. And this is actually yet another example of how the court is using price impact, price changes as evidence of behavior. On 1134 of your casebook, Halliburton contends that defendants should at least be allowed to defeat the presumption, the basic presumption, at the class certification stage through evidence that the misrepresentation did not affect the stock price. We agree. And then there's a discussion here of event studies. When you read the Alan Farrell paper, it'll kind of lay out for you the tension between materiality, which is now going to come back, and price impact. And this is convoluted, okay? You really got to follow this carefully. So that paper will give you the overview. In the next 5 minutes, I'm just going to survey, so you get a basic sense for what we're talking about, the class action landscape. A good paper, a good opinion to read on this is Amgen, which I don't think you have in the casebook at length, but you can just Google Amgen v. Connecticut Retirement Plans and Trust Funds. Amgen really lays out this is a 2013 decision by the Supreme Court, laying out not just the elements of a 10b-5 claim, and it cites Matrix. Unfortunately, I'm not sure we're going to get to talk a lot about Matrix. Maybe we'll touch on it next week when we revisit materiality. But there's a recap here of Matrix because Matrix lays out these elements of 10b-5. So Amgen cites Matrix. But in Amgen, we have also a summary of the procedural requirements to bring a class action claim. Okay, so for those who haven't taken this in Civ Pro or who have forgotten, let's just remember what we need to establish under Rule 23. So to bring a class action under the Federal Rules of Civil Procedure, we need to establish these 4 elements. Does anyone know them by heart? Civ Pro. Yes. Go, Lydia.
I think it's commonality, physicality, numerosity, and adequate representation.
Yeah, adequate representation. That was amazing. It reminds me I'm teaching my daughter you know the math songs 1 + 1 is 2. So I feel like that you had that down to a rhythm,
It's only because I just took math for class semester, so
There we go. See? Yeah, there it is. I knew there had to be a backstory to the speed at which you pulled that out. Yeah, absolutely. So we got to have numerosity. The alleged class is so numerous that joinder of all members is impracticable. There are questions of law and fact common to the class. It's got to be a commonality. the claims of the lead plaintiff are typical of the claims of the class, and the lead plaintiff will fairly and adequately protect the interests of the class. Now that's in 23A. Then we have 23B3. What is Rule 23B3 for the procedural among us? Fans of Federal Rules of Civil Procedure? Christian? I like the Federal Rules of You guys are, okay, yeah.
B3 is the
I'm not a fan of it, yeah.
damages class action where it's a permissive class and not a mandatory class.
23B3. So we need questions. Questions common to the class predominate, right? So the concern is that an individual will use the class action mechanism, even if they satisfy all the other, numerosity, typicality, commonality, protecting the adequate protection of their interests, they'll still use the class action machinery to get redress for their own specific harm, and that harm, the question that's being presented to the court is not so common, or the question that predominates is not so common to members of the class, but is actually reflective of just the individual's harm. All right, so this is the concern. And what happened in Amgen, and it's worth just rereading it, or reading it for the first time, is that the court said that materiality, if we think of the elements of Rule 10b-5, materiality is not necessary to establish at the class certification stage. So I will just... the question of materiality, this is on page 13 of the slip opinion, is common to the class, and because of that, and because of failure of proof on that issue would not result in questions affecting only individual members predominating, Connecticut Retirement here was not required to prove the materiality of Amgen's alleged misrepresentations and omissions at the class certification stage. So Amgen stands not only for a nice sort of summary of 10b-5 law, which you should read just to have it, but also for the proposition that materiality need not be established. How at the class certification stage? And there's a sort of discussion. Why? Because if materiality fails, the entire complaint fails, and that's really not the purpose. This is a fatal similarity. Well, some of you have to be like Civ Pro type. So, fatal dissimilarities versus fatal similarities. So this is a fatal similarity, which is not actually a fatal problem at the class certification stage. It's a merits issue, right? So if there's a fatal similarity, then that means that basically there's something wrong with your case, but it's similar to it's common to all of us, and so it should be adjudicated at the merit stage. Whereas if, in fact, we're just so dissimilar from each other, that's the kind of problem that's fatal to the class action and should be an issue up front at the class certification stage. Okay, so what's interesting is going back to 1134 in the casebook is that the court says just 1 year later, we agree that defendants should be allowed to defeat the basic presumption at the class certification stage through evidence. I quote from the opinion that, from Halliburton 2, that the misrepresentation did not affect the stock price. So although there is no need to establish, in fact, there cannot be a claim of non-immateriality at the class certification stage because it's not necessary to establish, it actually turns out that you can kill the lawsuit, if you will, at the class certification stage by showing that the misrepresentation did not, in fact, affect the stock price. So just in case you thought this could get any more complicated, all right, now we have yet another element in a way. It is price impact. Except price impact is being used to rebut the fraud on the market presumption. The lack of price impact, or as you'll see in the Farrell article, there are different ways to construe price impact, including like maybe the price was impacted by something else or by someone else's actions. Turns out price impact now becomes a way to defeat the basic presumption and thus require establishing transaction causation, which, as we know, is basically, no pun intended, impossible to establish, hence why we have basic. Okay, so for the weekend, read the article. It's detailed, has a lot of fun hypotheticals. Read Dura, because next week we will wrap up our discussion here of price impact, move on to loss causation and damages, which are the final element to bringing a successful claim under 10b-5. Office hours next week. Have a nice weekend.